Ready, start. Undoubtedly, the excess amount that has been paid to the appellant teachers was not because of any misrepresentation or fraud on their part, and the appellants also had no knowledge that the amount that was being paid to them was more than what they were entitled to. It would not be out of place to mention here that the finance department had, in its counter affidavit, admitted that it was a bona fide mistake on their part. The excess payment made was the result of wrong interpretation of the rule that was applicable to them, for which the appellants cannot be held responsible. Rather, the whole confusion was because of inaction, negligence, and carelessness of the officials concerned of the government of Bihar. Learned counsel appearing on behalf of the appellant teachers submitted that majority of the beneficiaries have either retired or are on the verge of it. Keeping in view the peculiar facts and circumstances of the case at hand and to avoid any hardship to the appellant teachers, we are of the view that no recovery of the amount that has been paid in excess to the appellant teachers should be made. In state of Punjab versus Rafiq Masih within bracket white washer bracket close, wherein this court examined the validity of an order passed by the state to recover the monetary gains wrongly extended to the beneficiary employees in excess of their entitlements without any fault or misrepresentation at the behest of the recipient. This court considered situations of hardship caused to an employee if recovery is directed to reimburse the employer and disallowed the same, exempting the beneficiary employees from such recovery. As between two parties, if a determination is rendered in favor of the party which is the weaker of the two without any serious detriment to the other within bracket which is truly a welfare state bracket close, the issue resolved would be in consonance with the concept of justice which is assured to the citizens of India even in the preamble of the Constitution of India. The right to recover being pursued by the employer will have to be compared with the effect of the recovery on the employee concerned. If the effect of the recovery from the employee concerned would be more unfair, more wrongful, more improper, and more unwarranted than the corresponding right of the employer to recover the amount, then it would be iniquitous and arbitrary to effect the recovery. In such a situation, the employee's right would outbalance and therefore eclipse the right of the employer to recover. It is not possible to postulate all situations of hardship which would govern employees on the issue of recovery where payments have mistakenly been made by the employer in excess of their entitlement. In the case at hand, the appellants were working on the post of stenographers when the subject illegal payment was made to them. It is not reflected in the record that such payment was made to the appellants on account of any fraud or misrepresentation by them.